it is necessary that we play a clip. This is an interview of Mr. Kganyago, the spokesperson of the NPA. And in the course of that interview, he commented about the legal status of the two documents that we are currently debating. With your leave, Chair. Mr. Matlala, if you could listen carefully to Mr. Kganyago's comments there.
We have to accept what the court has indicated. Obviously, it was not within our control as we had agreed, and there was a change of sentence, and they had a right, obviously, in terms of the law, to either agree or not agree, which they did not do.
This essentially means, Mr. Kganyago, that you have to go back to the drawing board. Anything that was reached in that plea agreement, including what we understood from this court, was an affidavit which contained the names of very senior police officers who are alleged to have also been involved in this rogue tender. You cannot use that anymore. You go back to the drawing board. He then also has to join the other police now who have been appearing in this matter. Clarification there.
Thank you very much. Yeah, definitely, because now the plea has been deemed to be null and void. Nothing that was in that plea can be used. Therefore, we have got to continue our own investigations from IDEC side. And then, obviously, the matter will come back here on the 11th of September. And what will then happen is we'll then ask for the court to then rejoin him as accused number one in the other case, so that he can now be tried. Because by not accepting the plea, he's basically saying, I will want to go full force in the trial. Therefore, that's what is going to happen.
Thank you, Chair. Mr. Matlala, I hope you heard that. That is Mr. Kganyago, the spokesperson of the NPA, expressing the legal position as a consequence of your rejecting the sentence proposed by the court in the plea and sentence agreement. And the point he makes, which is what we've been trying to persuade you of, is both that plea and sentence agreement as well as the affidavit you deposed to in the process of negotiation of that agreement, which you refer to as a Section 204, affidavit have become null and void. So they will not be used in that trial. They cannot prejudice you in that trial. And as the Chair, I think, pointed out, or Commissioner Baloyi, we are not part, this commission is not part of that trial. On that basis, Chair, I would seek to refer Advocate Missy in particular to Regulation 10, sub 6, which provides that for the purposes of conducting an investigation, the chairperson may direct any person to submit an affidavit or affirm declaration or to appear before the commission to give evidence or to produce any document in his or her possession or under his or her control which has a bearing on the matter being investigated, and such person may be examined by the chairperson or an evidence leader. That's Regulation 10, sub 6. I'll take it further and reference the rules which at Rule 10 call for documents. At 10.3, the rule provides that should a person claim that a document referred to in the summons, which is the document required, is subject to legal professional privilege, they must, 1, identify the document in respect of which privilege is claimed, and 2, explain the basis for the claim of privilege in relation to each document. The remainder of that rule then deals with the questions of confidentiality and, of course, confirm the chairperson's discretion to determine that certain portions of such document or the document in its entirety is subject to a claim of confidentiality, which claim will be upheld by the chairperson. That's at the chairperson's discretion. Based, therefore, Chair, on Regulation 10.6, we would request that the Commissioner's rule, the Chair rule, that Mr. Matlala, and by extension, of course, his legal team, make available to the evidence leaders and the Commission, purely because Mr. Matlala, at every turn and in response to every question, invokes the Section 204 statement, or affidavit, to make available both those documents for consideration by this Commission to determine the extent to which the contents thereof are relevant to the matters before the Commission. Thank you, Chair.
Ms. Sidlo, I'm loath to make such a ruling without full written argument on the point. I'm not sitting here I'm not altogether sure how Section 105A10A should be interpreted for purposes of whether this commission can, regardless of the nullity, have access to and use the affidavit that was produced in the context of the plea bargain proceedings. Sitting here now, I'm loath to right away make that kind of, of ruling. I would have to be addressed fully and with written submissions on the point. I was making a slightly different point when I engaged Ms. Missy right at the end before the adjournment. I was saying we got to the point that raised the question of whether this commission should have access to that 204 statement. We got to that because Mr. Matlala chose blanketly to rely on that statement to assert the privilege. And the point I was making was the proper approach for Mr. Matlala is, in accordance with paragraph 109 of the Constitutional Court judgment, to refer to a specific crime, the paragraph says so, and say because of that specific crime, this is how that question impinges on my privilege, and therefore I assert the privilege. For that purpose, he ought not to rely on the fact that he has made a 204 statement, because that doesn't specify the crime on the basis of which he is asserting the privilege. So it is why, that's why I said we ought not and we should not have reached the stage which we reached. We reached it because of the blanket manner in which Mr. Matlala kept referring to the 204 statement. We should not get there. I would suggest that between now and the time that we adjourn, you put your questions again. And Mr. Matlala, I repeat, and this was the purpose of the adjournment, I repeat that I will not accept blanket references to your 204 statement, because the 204 statement is not in and of itself a specified or specific crime, a specific crime for purposes of the judgment that I have referred to, and which is authority on how and under what circumstances you can assert the privilege. So do not again blanketly refer us to your 204 statement. Tell us the crime and then claim your privilege. So for now, let's just proceed with your questions on the basis that I will hear nothing of this blanket reliance on the Section 204 statement. And if you insist that we should have sight of that statement or affidavit, I will insist on being furnished with written submissions by both sides on that issue, Mr. Silo.
I accept that, Chair, if I may, with your leave extended. Much as you say, Mr. Matlala, in refusing to answer a specific question posed to him, must specify this, the offense, which is what section, paragraph 109 of the Zuma judgment tells us. Equally so, the point I sought to make and the purpose for which we played that clip is that very document is null and void in the very criminal trial that he's currently facing. So he can't invoke it for purposes of a fear that it will prejudice him in those proceedings. So he can raise that as well.
Yeah. I hear you.
Thank you, Chair.
I think that's a valid point. Yeah,
Thank you.
I hear you. Thank you.
So then, Mr. Matlala.
I hope because when we took the break, Ms. Missy, that was the point on which I was engaging you. That is, I will have none of this thing, of this blanket reliance on the Section 204 statement. That's when you and your junior engaged each other, and when I said, let's rather take an adjournment rather than watch you engaging with each other. So I hope you did engage Mr. Matlala on the point, which is the point I raised with you specifically, and that Mr. Matlala now understands that he cannot in a blanket fashion just say, because this was in my statement. But in any event, Ms. Silo makes a valid point, which is that the fact that it's in that statement can't be used against him in the criminal proceedings anyway. I'm just expressing a hope that this was discussed fully. I hope I'm not inviting a debate.
No, Chairperson, you're not inviting a debate. I can confirm that we did impress on him and explain to him why you're taking issue with it with regards to the blanket statement. And so I do hope that moving forward, he'll be able to answer you as per that issue.
Thank you. And Mr. Matlala, the point I'm making applies across the board, actually. It's not just about the Section 204 statement. It applies to any and every issue that may arise upon, or rather, based on the questions that you are going to face from Ms. Zillo. So you cannot, in very broad and generalized terms, say that's going to incriminate you. We should know what the crime is, and then based on that and looking at the question, see whether indeed your asserting the privilege is warranted under those circumstances.
Thank you,
Yes,
Chair.
yes, Ms. Zillo.
I take it, Mr. Matlala. Did you want to say something, Mr. Matlala? You looked at the chair like...
Yes, if you want to respond, you may, Mr. Matlala.
No, I actually acknowledge what you were saying. There's nothing more.
Then how we got here, Mr. Matlala, was we were engaged on your third, fourth, whatever, incident where you met with General Sibia and you said that he had invited you to discuss the kidnapping of Mr. Bushoha. You then suggested that you cannot go in any further detail as to that engagement, and for that purpose you relied on Section 204 statement. So now it says you can't, not in the manner that you choose to, because in any event that statement itself has become null and void. So then I repose my question. Can you briefly state to the commissioners the nature of the engagement you had with Advocate Sibia, General Sibia, about the kidnapping of Mr. Bushoha? My apologies, General Sibia.
I think on that issue, I already said that he asked me what do I know about it, or you want me to explain what did I say to, after he asked me what did I know about this kidnapping, do you want me to explain what did I say to him?
Yes.
Okay. Yes, he started by asking me that why are they accusing me actually of that crime? And I took him back and I explained to him that as soon as Jerry was kidnapped, I suspected two things. The first one was I went to Jerry's house together with Jerry's brother. And then Jerry's brother said to me, I must ask Jerry's wife to give me Jerry's cell phone, because should she find out that there is Jerry's side chick's number in that phone, she will go crazy. And then she said I must lie to her and say this phone is going for investigation. And I did that. That's the first point. So the second one is I told Jerry's wife and Jerry's brother that why don't we tell the police exactly what was Jerry doing, so that at least when they looking for him, they will know which direction to look for. And then I think those two things might have triggered what Jerry's wife did to end up saying, I kept Jerry at my house, which is not true anyway. So, but those are the things that I discussed with General Sibia.
And are you able to say what was the outcome of that engagement? Because it's not clear whether he was talking to you or with you in his capacity as an investigator, having taken over the investigation, or purely as a senior police officer where others are investigating that kidnapping.
What he said to me is, he said to me that if he can crack that case, it will help him a lot. So I will assume that he was doing that as a police officer, obviously, because if he wanted to be the one maybe to crack that case, then he wanted to know what do I know about it, since Jerry was my friend.
And I think earlier I asked whether after that engagement you had any further interaction with him about this matter.
The kidnapping matter?
Yes.
No, he never, it was only that time.
Okay. Now, you recall that we were dealing with these issues because paragraph 2.2.3 and 2.2.4 had inquired of you the nature, extent, and frequency of communications and physical meetings with General Sibia. We had said this perhaps is about your third encounter with him. When next did you meet with him and for what purpose?
The other encounter, I said, is the one that I do not want to talk about it because I'm being charged with corruption. I'm not talking about 204. I'm being charged with corruption, and then they also investigating him on that matter. So
Please say the last bit again, and also?
the investigators, they are also investigating him. Firstly, I'm describing the crime. So I
Yes.
said I'm being charged with corruption.
Is this in the Pretoria case,
The Medicare, yes,
the Medicare case?
yes,
Oh, this is corruption in the Medicare contract.
yes.
Is it part of the ongoing criminal case, or would that be an extra charge?
Ongoing criminal case.
So you then, this corruption that you fear you may face a charge for arises from your physical meetings and gatherings and communication with General Sibia.
That is correct.
And would both of you be charged with corruption, or just you?
I'm already charged, so I'm saying I do not want to say things that will end up making my trial difficult for me. Basically, what I'm saying is it will infringe my fair trial rights.
Okay. So that will infringe your rights in the ongoing corruption charge in what we call the Medicare?
Yes,
Because corruption is one of the offenses you are
Yes.
charged with.
Is this the IDEC investigation?
yes, that's correct.
And this would relate to your interaction with General Sibia. You may disclose something, you say, that would compromise your defense against the corruption charge if you were to speak about this fourth interaction with General Sibia.
That's correct.
Okay. And thereafter, any other?
There's two occasions, but both is the same corruption charge, yes. I'm not mentioning when I went to see him in his office for the Jerebo issue and also for the public works hospitalities.
So, if I understand you correctly, after your engagement regarding the kidnapping of Mr. Bushoka, you met with General Sibia 3 more times.
Commissioner, I'm just saying, I cannot guarantee that it's 2 or 3. I'm just saying from the top of my head, I'm not sure about that.
And where's my 3? You had said, I said, when was the next time you met? And then you brought up the corruption case in Medicare. And I say, beyond that interaction, any other, you say 2 other occasions. That's how I land on my 3.
No, I said except the 2 other occasions when
Okay.
we met in his office. 3 occasions, actually.
So now you had this interaction that could potentially undermine your defense in the ongoing corruption case. I want us to get past that interaction. I want the next time you met with him.
There is no next time.
Was that the last interaction you had with him?
Yes, the last interaction is, I think, is what is it called? That engagement party. I don't think there was after that. I don't recall.
So the next time you met with him thereafter, to your recollection, was perhaps the engagement party you referenced earlier? You have to verbalize your answer.
Yes, I said that, Commissioner.
Don't nod, Mr. Matlala.
I'm sorry. Yeah.
The recording doesn't see a nod. And since the engagement party and the interaction at the engagement party, have you had any meetings, physical or otherwise, communications with General Sibia?
No, I've never.
When was this engagement party, to your recollection?
Sometime in 2024.
So you said, okay, you can use the season, winter, summer, I'm trying to...
I think it was towards the end of winter, if I'm not wrong.
So I can say mid-year 2024.
July, maybe July, somewhere
Okay.
there.
Did the other witnesses not say it was 14 September?
No, I'm not sure, Commissioner. I'm not saying that. I'm just.
There's confirmation that, yes,
Yeah.
the other witnesses so said.
He might be right. I'm not.
Okay.
I'm not saying that is the truth.
So then I'll accept that. The last engagement you had with, or interaction you had with him was at the engagement party in 2024, whatever the actual date was.
Not the last. The timelines, I'm a bit confused with them.
Yes.
But it's one of the interactions, yes.
Okay, then let's get past the engagement party. When did you next engage and interact? After, now we have the engagement party in our minds. I trust fund was heard by all. So after that, when did you next engage?
What I can remember is only...
Sorry to do this.
Yes, Commissioner.
There's confusion about the third and fourth occasion. If the engagement party was in September,
Yes.
and the raid was on the 6th of December, then it must mean the engagement party is the third occasion and the raid is the fourth occasion, because December comes after September.
Indeed. Do you understand?
No, I understand, yes.
Yes. Remember we discussed the kidnapping of Mr. Bushokha?
Yes, yeah.
And you said it was after the raid.
Yes.
So the commissioners point out to us that the order of things is not right. The engagement must have come before your engagement with him regarding Mr. Bushokha, because that was only after the 6th of December.
Of course, yes, I agree.
So we should swap the dates around.
Of course, yes.
You said yes.
Yes,
Oh, you're still thinking. I don't know.
I'm thinking.
I don't want to rush you.
I'm trying to remember. I think, if I'm not wrong, I also met him in 2025. So I'm trying to remember while speaking. I'm sorry. So I mean, I was trying to get the exact date.
Then perhaps if we say, while we correct that, you then met him next in 2025, perhaps if we discuss the circumstances of that meeting and what was discussed, that would help us sort out the order of things, hopefully. So what did you, in 2025 when you met, what was it about and where and how did it come about?
Commissioner, I'm saying I think I met him in 2025. I'm not certain, but judging by the timelines, because after the raid, I remember I didn't have, there was no way after the raid, first, I'll say maybe 15 days, there was no way that I could have seen him because I was busy with police and then I was busy with my meeting with, so it must be maybe January, I think.
Oh, okay, I think I get you now.
I'm trying to have a proper recollection, so.
And is that in relation to the discussion around the kidnapping of Mr. Bushokha? That's the one you are putting it around January 2025, am I understanding you correctly?
Yes.
Okay. So then, after the Mr. Bushokha discussion with him, when you would have met again?
I don't think I've met him again after.
Since?
Yes.
Have you ever communicated with him directly or via Sergeant Ngosi?
Communication, yeah, I think there was a communication via Sergeant Ngosi, yes.
Are you able to just highlight what the communications was about and who had initiated such communication? And if they are different, then you can enumerate each and talk about who had initiated and what each communication was about.
The communication was through, all the time, was through Sergeant Ngosi.
But at whose instance?
If I remember well, the communication was regarding after the raid, why did I tell the police that I know him? So, I think it should be in December. After the raid, maybe before January, I think there was a communication.
Okay.
I'm just confused. I'm not.
Okay.
I'm sorry. I am not.
Are you now referring? Remember, there were two raids in December. There was a raid at your house.
Yes.
Where the police were looking for Mr. Bushokha. Then there was a raid at CAT VIP Services where there was the issue with the key and the fact that it's not in the right safe and firearms were taken. Which raid are you referring to?
After the first raid, I think 10 days after the first raid, that's when, 10 days after the first raid, that's when I made that High Court agent application. And in that High Court application, that's when I mentioned that I know General Sibia. So that's when I get a message from Sergeant Ngosi that why did I mention that I know him? Because it was in the media, I think. So that's why I'm saying I think in December there was some communication.
So after the 20th of December?
Yes, somewhere there, yes.
Thank you. So do you recall having a discussion with General Sibia about an application that was necessary to launch for the return of the guns and I think jewelry you said had been seized during the raid of your house or office, one of them?
Yes, but that is part of the case that I'm attending in the Johannesburg High Court.
Medicare?
No, not Medicaid, the other one. In Johannesburg High Court.
The one concerning the conspiracy to commit murder, attempted murder, and
Yes.
lawful possession of a firearm and ammunition, money laundering.
Yes.
What relevance does General Sibia have?
There is a relevance because I have to, my defense, I need to establish how did I end up being arrested. So because in my phone records, they are relying that I'm part of, me and General Sibia and Minister Mchunu, we part of people who plan to dismantle this PKTT unit. So that is something that I'm going to argue in trial, that how did I end up getting arrested.
What is the crime in dismantling the PKTT?
The crime.
You said, perhaps I misheard you, my apologies. You said there is an accusation that yourself, General Sibia, and Minister Mchunu are what about the PKTT?
Commissioner, when they did my cell phone downloads, there was communication which I do not want to, but it's part of evidence in my criminal court in the Johannesburg matter. But there is those engagements and where also General Sibia has been involved there.
You said something about the PKTT. Can you say that again?
The dismantle, of the T.
Oh, yeah, okay.
Yes.
So that's why I say, what is the crime in disbanding the PKTT? What's your understanding
It's
arising from that case?
Not the crime, not the crime commission. I'm saying part of my defense. I'm going to establish in court how did I end up getting arrested. The only way for me to explain this to you now, I have to go deep, and which I do not want to do that, and now disclose my defense strategy.
No.
I do not want to do that.
I'm not inviting you to. I was talking about an application you initiated or instituted in December.
Yes.
For the return of your guns and jewelry, which had been seized during one of the raids.
Yes.
And I asked the question whether you had not engaged with General Sibia around that application for the return of your property. So your response then speaks to the criminal case of murder and attempted murder and the disbandment of PKTT. And I'm not sure I understand.
Because your question, what you're asking me now,
Yes.
is also part of evidence. What you just asked me now is part of evidence, which is in my cell phone download.
Isn't perhaps, Mr. Matlala, the best way to proceed is the direct question that is asked is, you had such an application before court where you went to court to seek a return of your firearms. That's what Ms. Silo has asked at this point. So it seems to me that your answer would be yes, I did, or no, I did not. And then we pass that, and let's hear what is the next question before you get to a point where you say, but that case has to do with the matter that I'm presently facing and the defense. So maybe take it step by step. At this point, all she asks is, you had such an application where you went to court, you wanted a return of your guns and jewelry. And answering that question at this point does not require you to get into the detail of that application, and I don't know if she intends to ask you that further question, but at least as a starting point, your answer doesn't require you to speak about what was in that application.
Commissioner, I already considered that, yes, I made that High Court application, but the next question was, did I ever discuss that with General Sibia? That was her question.
And your answer could be yes or no, and if she says, what did you discuss? It seems to me that at that point, you may well attempt to raise your defense, your privilege.
Commissioner, I don't think this is fair, because now I'm disclosing part of my defense strategy now. I don't think that is a fair move. I don't think so.
You are not, at least as I understand, you are not saying, I don't want to answer that question because it will incriminate me. You're saying I don't want to answer the question because I don't want to disclose my defense strategy.
That's correct.
So it's the second one.
Yes, that's correct.
And Mr. Law will decide whether that's good enough for purposes of further discussion.
Well, I would think that, and perhaps it's a tad unfair to Mr. Matlala, because the answer really lies in Section 3, Sub 4 of the Act, which means he must invoke some legal privilege. And in regulation, I think 610, it tells you that the only basis to refuse to answer a question is if you establish a privilege contemplated in Section 3.4, which is a privilege as recognized in law, and fear to disclose your defense as not one such privilege. So if that is the only basis, then you do not bring yourself within the ambit of the protection, because that does not constitute privilege, and you will be compelled to answer. You are raising a wrong basis to refuse to answer. It's not an acceptable basis, as determined by the law, not by us around here.
Maybe, Commissioner, is because you are speaking to, I'm just a mere layman. I do not understand the law, and then I do not know which case law I should invoke in these things. I think maybe my legal counsel will help me with that. I do not know how to invoke which section for that.
I think that's fair. That's fair. So maybe to address myself to the commissioners and ask the commissioners to inquire from Advocate Missy whether she would like to engage with that point on your behalf.
Thank you.
Thank you.
Ms. Missy,
Should I answer?
what are your
May I answer
submissions,
rather?
your submissions in response?
Yes, Chairperson.
Does the privilege extend to not, or rather, yeah, a witness saying, I will not answer because I do not want to divulge or reveal my defense strategy?
Chairperson, at some point you raised the question as to what exactly is this charge that you are facing that speaks to that particular piece of evidence and defense that you would not like to disclose before the commission. One, because we were only briefed with regards to the proceedings before the commission, we're not fully aware as to what are the charges that he faces in that matter that speak particularly to that piece of evidence. For us to then say to Mr. Matlala, we do understand you, and from this perspective here, you would be able to claim your right to the privilege in terms of Section 3.4. And so, Chairperson, the only thing that I could do at this moment is if the Commission could allow us to stand out so that we can consult with regards to this issue, bearing in mind that we're also in a back footing with regards to the charges that relate to that case before the Johannesburg High Court, I believe.
Just repeat the underlying facts that give rise to this issue. So that when instructions are taken, they are taken in the context of or the point from which you moved to,
Yes.
for us to get to where we are now.
The chair will recall that Mr. Matlala and I were recounting the incidents he met with General Sibia and they discussed, and the idea was to understand the content of such discussions on each incident. And I had posed a question to him whether he had met with General Sibia regarding an application he instituted for the return of his firearms and jewelry, which he stated at the time had been seized during one of the seizure, one of the raid incidents, either at the home or subsequently at his office. And he confirms, yes, he did institute those proceedings. So the question was whether or not he met with General Sibia and discussed that with him, to which then he claimed he invokes a privilege, not in the Medicare matter that we've been dealing with, but the other matter in Pretoria, I think, about conspiracy to commit murder, attempted murder, unlawful possession of a firearm and ammunition, as well as money laundering. So it is in the context of understanding the charges that he's facing there, I'm trying to appreciate what his engagements with General Sibia regarding, I would term it the lawful return of his property, what bearing it would have on that case. And that's where I think we fail to find one, or I fail to understand, let me lay it on my doorstep.
Thank you. Yeah, maybe for a fuller background, during the raids, some of Mr. Matlala's companies, properties, and indeed even his